Breaking news. Court adjourns Nnamdi Kanu's appeal against terrorism charge to give date for judgment. Arguing the appeal, Chief Ozekome's son alleged that his client was forcefully adopted from Kenya and illegally redemptioned back to the country. Hi guys, you are welcome back to Prospect Channel TV. Thank you very much for always coming out here. May God bless you all. The Abuja Division of the Court of Appeal has reversed its judgment on the appeal filed by the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, to quench the terrorism and treasonable felony charge the federal government preferred against him. Sahara reporters had reported that Kanu, who is currently facing trial before the Federal High Court sitting in Abuja, had, through his team of lawyers led by Chief Mike Ozekome, a senior advocate of Nigeria, SAN, approached the appellant court to interrogate the illegal competence of the charge pending against him. Justice Binta Inyako of the Federal High Court, Abuja, had struck out 8 of the 15 counts charged the federal government filed against the IPOB leader. But Kanu's lawyers appealed against the remaining of the trial court on April 8 and sought the appellant court to review the remaining and struck out the remaining 7 counts pending in the lower court. The lead counsel of the IPOB leader had insisted that the charge the federal government of Nigeria entered against his client had no basis in law. In the appeal dated April 29 and marked CA/ABJ/CR/625/2022, appealed to be discharged and acquitted. Kanu equally urged the appellant court to order his release on bail pending the determination of his appeal. Though the appeal court was initially fixed for October 11 following an application, the embattled IPOB leader filed for abridgment of time. The appellate court brought the matter forward for hearing. When the matter was called up on Tuesday, a 3-man panel led by Justice Joma Hanutu said it had no need to delve into the issue of bail since the substantive appeal was ripe for hearing, according to Vanguard. Arguing the appeal, the Chief Ozekome's son alleged that his client was forcefully adopted from Kenya and illegally redemptioned back to the country. He told the court that his client was first arraigned in December 23, 2015 and was later granted bail on April 25, 2019. My lord, he was enjoying his bail without breaching the terms. However, he was in his ancestral home when agents of the respondent invaded his home in September 2017. He barely escaped alive by sheer providence and found himself first in Israel and later in London. When the appellant traveled from London to Kenya, agents of the respondent on June 27, 2021 forcefully adopted the appellant, tortured and redemptioned him back to the country, Nigeria, without following any extradition process, Ozekome submitted. He argued that under the doctrine of speciality as provided for in Section 15 of the Extradition Act, the federal government of Nigeria had to have proceeded to try Kanu on the 5-count charge he was initially facing before he escaped from the country. He urged that Kenya, being the country from where Kanu was arrested and extraordinarily redemption back to Nigeria, had to have authorized his extradition. This allegation of his forceful abduction and redemption was never denied by the respondent. More to my lord, The charge appears to give the lower court a global jurisdiction over offences that were allegedly committed by the appellant without specifying the location or date the said offences were committed. There was no need for the lower court to have retained the remaining 7-count charge. We are therefore urging my lords to strike out the remaining counts and hold that the respondent has not established any prima facie case against the appellant for which he could be tried, Ozekome added. Meanwhile, the government lawyer, Mr. David Kasui, urged the court to dismiss the appeal for want of merit. He maintained that the IPOB leader was brought back to the country by due process of the law. According to him, the charge has been amended 7 times owing to the conduct of the appellant. My lord, it took 4 years and huge resources to get the respondent arrested and brought back to face the charges against him. The prosecution is ever willing and eager to proceed with trial of the appellant. We are saying that the trial court was even wrong to have struck out the 8th count as it did. It is only after the federal government has produced all its witnesses and tendered its evidence that the appellant could claim that no prima facie case was established. Finally, we urge the court to dismiss the appeal for lacking in merit, Kasui added. After it had listened to both sides, the panel said it will communicate a date for the judgment. Meanwhile, the court has struck out 1 of the counts in the charge, leaving 6 for determination. So guys, I'm dropping it here. Kindly share your thoughts below in the comment section.